The Honor Attorney Kevin Mant, P71061 on behalf of Mr. Dion Lyons. Mr. Lyons, state your record.
Dion Lyons. All right, we have checked and shared with council sidebar. I'm looking for their actual written response. Which is what I kind of suspected. There's one drug in here that may show up as opioid, but would not be picked up on our test. That's a simplified version of the answer. Would not test positive on our test as an opiate. And specifically, Community Corrections informs me this is not an opiate drug, mainly because selling that at a gas station would indicate that that gas station would be charged with a felony. They were selling a narcotic. But then additionally, specifically, they very clearly indicate it would not show up on our drug screen as an opiate. So, how many of these supposedly did you buy?
So, you want me to respond, Judge?
Yeah.
So I talked to my client, Judge. He said he was taking them for 5 days straight,
Well, all right.
And may I address the bond issue, Judge?
Yes, you may.
And so, Your Honor, first and foremost, I don't think Mr. Lyons is trying to evade the court in any way, shape, or form. I did have an in-depth conversation.
This matter concerns bond compliance proceedings involving the defendant, identified as Mr. Lyons, also referred to as Francisco. The case arose during a probable cause conference in which issues regarding alleged bond violations were brought before court. The central concern involved drug testing irregularities and potential narcotics use, while the defendant was on bond supervision through Community Corrections. The defendant had previously tested positive for opiates on the 10th of the month. However, defense counsel asserted that a more recent test conducted by Community Corrections was negative. The defense maintained that the only substance consumed by the defendant was a product allegedly purchased at a gas station, which Community Corrections indicated would not test positive as an opiate under their screening protocol. The court emphasized that its testing procedures are capable of distinguishing between heroin, fentanyl, and other opiates. Additionally, the record reflects prior issues involving Suboxone in the defendant's system, absence of prescription, and prior THC use. The defendant also faced allegations of untimely drug testing, including late submissions and 2 failures to appear. The case proceeded with discussions concerning bond revocation, compliance monitoring, and potential modification of testing conditions.
Conversation with my client, and Judge, he's still adamant that those were the only any type of drug or I don't want to say prescription, but those are the only things that he has consumed. And I know what the court's position is. I know what the test says, but my client is adamant that that's it. What I would note, Judge, is that prior to this test, he had tested negative. On the 10th, he tested positive for opiates. However, he tested today with Community Corrections, and from my understanding, it was negative. That there's nothing in the system as of right now. My client is adamant that there will be nothing in the system going forward. I know that a report showing that he had opiate is technically a bond violation, but my client has been trying to wean himself off of any type of narcotics since the day he got tested, when he had the Suboxone in his system, which is clearly no longer in his system. He stopped with the THC and the marijuana. That's why no THC is in his system. And now we're left with this particular incident. And so, Judge, I guess what I'm asking the court for, given the fact that he did technically test negative today, if the court would give him one more opportunity to prove himself that he can stay clean, that he can stay negative, and not consume any type of narcotics of any sorts from this point forward. I believe that Mr. Lyons will do so. His mother is scheduled for a major surgery where he is set to be her caretaker. And so I'm hoping the court will continue his bond to allow him to do that as well. But with that being said, Judge, I'm asking the court not to revoke Mr. Lyons' bond, but to give him one more opportunity to prove to this court that he can stay negative with his testing. Yeah.
Anything from the people?
I have some concerns. I know the last time we were here, we had some concerns about the Suboxone. They didn't have the prescription, and we're working through that. And I understand that. I'm concerned now that we're here. It's opiates. Community corrections says these don't match with what the test results are showing the product that he brought in. So I have concerns. That point.
As far as the case, what do we want to do on the case?
Defense counsel is prepared to set it for a preliminary exam.
I won't. Here's what I'm going to do. I'm not going to, at this juncture, set it for preliminary examination. I'm going to adjourn the probable cause conference out 1 week, February 26, 2026 at 9, or as your Zoom invite indicates. At that time, I'm also, if you want, I will set a hearing on the bond violation. I'll get the people over here, let the prosecutor know. I'll get the people from community corrections to testify if we need to regarding that drug and what shows up on their test results. I'm going to indicate to you, young man, I'll be honest with you, with what I know right now, I may learn something later. I don't believe you. I think I'll tell you what I think is happening. I think you're trying to get yourself off of the drug. You were taking the Suboxone. You have an opiate addiction. You're taking the Suboxone. You want to get yourself off of the Suboxone. That is clear. You want to have yourself clean, and you had a moment of weakness. And that's why an opiate is showing up. Now, you can shake your head all you want. I've been watching. I've been doing this for a long time. And you can come in here and then try to show me something that you say shows up as an opiate. Our testing is so sensitive. I mean, our testing distinguishes between heroin, fentanyl, and an opiate. We can distinguish all of those different drugs as to what somebody's taking. And so this product would not show up as an opiate. And at some point, quite frankly, you're going to have to come to the realization that, and I think you're an addict. And you're going to have those moments. But the problem is, when you have those moments, you're going to have to be honest about it. And I don't think you're being honest right now. And I think there may be other reasons why you're not being honest, but you're not being honest. Because the only way that you're going to manage your addiction is if you are honest. So I will set this for a hearing. Counsel can let us know if he really wants to go forth with the hearing, but people would be expected to have the people here. I've set it out 1 week actually I'll set that at 3 p.m. for the hearing. I'll set his PCC also at 3 p.m. At this point, however, your bond is revoked. Defendant's remanded pending that hearing. Your name?
My name is Francisco Andres Casale.
Your Honor, I know the court would like to address the bond violation first.
Yes. There a particular reason you can't test on time?
I'm sorry, Your Honor. I try to do it just with having kids, and I'm in a busy life as a single dad. It's kind of hard to take track of the times, but I will be more on top of it if you give me another chance.
Did we set an order on this one, or we just got it?
Yeah, we just got that yesterday, Your Honor. This is the first violation.
And Your Honor, I've spoken with Mr. Cazetta Loretta, and I asked the same question that the court did. He indicated to me that he thought that as long as he got the test in, that he would be fine. I told him that these time blocks in which he's supposed to test by.
I don't know what that meant. As long as he got a test in.
As he's supposed to test between 6 a.m. and 9 a.m. and he tests at 9:18 a.m. because the majority, if not all of these, are for late tests. I tried to look through every last one of them. I don't think that there were any There were a few missed tests very early on in December.
I
But-
guess I'm unclear though as to why, if I give you 3-hour windows, you can't find the time in those 3-hour windows to test.
Your Honor, he explained to me that he has been extremely overwhelmed with his children, his work schedule, which is those are the different reasons that he's been testing late. Sometimes he wouldn't even have the device on him when he was at work or elsewhere. I told him that this is a very serious situation. I would say that the positive is that he has not had any positive tests. And I know that weighs a little bit because obviously the court has required that he test timely. I have spoken with him. He informed me that he's currently on probation out in Kent County in Kentwood. I did supply the court with another document. I spoke with his probation officer in Kentwood, and she states that he is currently testing with them 1 to 2 times weekly. He's doing ETG tests as well as it's a dipstick test is how she described it. And he's doing the ETG tests and it tests for drugs and alcohol. I have provided the court, I asked her to submit a write-up explaining the results of those tests. She did submit it to me. I forwarded it to his community corrections agent, and I furnished a copy to the court as well as the people.
When was that?
Today, Judge.
Did we get something from?
Yeah, it's in the file. And what you're gonna be ready.
Yes. So, Your Honor, and I asked specifically, I know in the initial paragraph, she describes the type of testing that he's currently doing, but in the body of it, it does not say alcohol. She says that if it does not say he's positive for alcohol, then he has not tested positive for alcohol. And she has confirmed that all of his tests have been negative. He does have the positive THCs, but he has a medical marijuana card.
Justice has 2 failed to appears.
So the 2 failed to appears. He's telling me that he was in another court that date. I'd have to confirm the dates, but Your Honor, he did not start testing in our court until 12/12 is when he was required to begin his testing. So from the time frame that he's been testing with us, he has been very consecutive with his tests in Kentwood as well, and he has been negative for everything there, except for the positive THC, which he has the card for.
Can't seem to do anything on time. Why was he late today?
Your Honor,
I was late coming over here. I stayed out in Grand Rapids, so I had packed my family up and I took off. And right 30 minutes before I remembered about my apparatus and the test, so I turned around, ran home, did the test, submitted it. And I brought the apparatus with me just in case. I deeply apologize for the time frame, sir.
and Your Honor, typically the court has been very generous in allowing him to log in on Zoom. I think the court can remember when this case was first called today, I informed the court that we did not make that Zoom request because we knew the court would need him here in person to address this.
And you're asking for an adjournment.
We are, Your Honor. I'm in communications with the people in regards to a resolution.
All right, we'll be sending it over to Ralph, indicating that you are not to have any more missed tests. That's how I'll handle this unless you want me to switch over to a SCRAM unit.
And Judge, I did speak with him about a SCRAM, and I think that would be best with his
Wait,
small
you're switching,
children.
okay.
Judge.
All right. Then we'll switch him over to a SCRAM testing unit.
So thank you, Your Honor.
How much time did you?
I think 2 weeks would be fine, Your Honor.
Probable cause conference will be adjourned March 12th, 2026, 9 a.m.
Thank you, Your Honor.
Bond will continue with
Thank you.
the change in it being the SCRAM unit. You can head over there now if you have the other one to turn in.
Okay, thank you, Your Honor.
At the conclusion of the hearing, the court formally revoked a defendant's bond based on suspected opiate violation and ordered him remanded pending further proceedings. A hearing on the bond violation was scheduled for February 26, 2026 at 3 p.m., with the probable cause conference also set for that date and time. The court indicated that community corrections personnel would be expected to testify regarding the disputed drug result if the defense elected to proceed. In a later proceeding addressing repeated late testing violations, the defense requested an adjournment while engaging in discussions with the prosecution toward a possible resolution. The court agreed to adjourn the probable cause conference to March 12, 2026 at 9 a.m. As a condition of continued supervision, the court ordered a modification of monitoring procedures. The defendant was transitioned from his prior testing arrangement to a SCRAM monitoring unit to ensure stricter compliance. The court instructed the defendant to report immediately to exchange equipment. Overall, the case remains pending. The defendant's bond status was revoked in relation to the opiate allegation, and enhanced monitoring conditions were imposed in response to ongoing compliance concerns.